Whereas we know the huge amount they spend when they are having their conferences. So kindly note that they have been giving us moral support. They have been giving us moral support. They have been giving us moral support, especially in establishing marital relationships. They gave a very comprehensive lectures at the camp on marriages and how to establish relationships. It's one of the reports I received there. So that is that. Secondly, those who have been supporting us hugely, they are not members of the companion. And should not continue to run companion this way. We should try as much as possible to come on board and get massive support from members of the companion. Let me quickly just mention 2 families. Alaji Oyemi has been giving us 2 cows and 10 bags of rice since last year. And he's not a member of the companion. Dr. and Mrs. Banero today have been supporting us heavily. And this Crown Flower Mills Limited, where Alaji Moshood Kodri is the DGM personnel, they have been giving us both their products and financial support. So let us help me to recite in Atina for those who have been supporting us. Secondly, the issue of our sitting arrangement. Let me first commend the district for improving on the turnout of this program. It has been our plan, and that was why 6-7 years ago we changed the venue, we rebranded, and we tried to also change the program content. The present administration has been able to let me say, move the stake higher. We recorded massive turnout last Usrah, so ditto for today. We need to address the issue of this lack of chairs or lack of enough chairs for this program. Then lastly, the Islamic vacation course, where I think many of us we have attended in our days in MSS. We had the all 100 IVC in Ibadan recently, and what we are giving to those who have been supporting MSS. Our observation is that we have tried it in the companion. We have succeeded in making sure that the 2 formal openings that do not clash. We succeeded in getting it done this last one. Let us try as much as possible to show interest in Islamic vacation course, which is a program that produced many of us in companion and criterion. And our own brother, Brother Abdul Fattah, Abdul Karim, and Abdul Majid was one of those people giving an award for his contribution to, I think, MSS. And I was also giving an award for my contribution to MSS and some other companion members. We are yet to see the impact of criterion again in IBCs and MSS programs. Don't let us forget our roots. Our more companion members too should show interest. Once again, I want to end my discussion, my contribution by commending the leadership of this district. But I must also say that the district is not well funded. I can say this because I discuss regularly. So if it is this program I want to support it. If it is the companion district I want to support it. I think we should also extend request to the criterion on this program so that we can raise the tempo and we can increase the attendance. May Almighty Allah empower every one of us, prosper all of us, and accept our acts as ibadah. Assalamu alaikum warahmatullahi wabarakatuh.
So what we do is we take all the questions together and then you address them together. Question number 1 is, what of those who had already done wedding before they have good knowledge of Islam, i.e. those who have done registry wedding before they have knowledge? What is the way out? That's the first question. Now number 1 proper.
Assalamu alaikum warahmatullahi wabarakatuh. I thank our brother for the lecture. My question is this. While he was giving the lecture, he said that one of the reasons that distribution of sharing of inheritance can be delayed is in payment of debt. Now, can we put school fees as debt? For example, we have seen some fathers, when they die, they put in their will that the last child will be 25 years before the inheritance is shared. I think what is responsible for this is to try as much as possible to secure the last child's probably education or whatever. So can we put cases like payment of school fees, for example, if somebody dies and the last child is in the university, and the fear of probably if the inheritance is shared, the amount that we pay to that child might not be sufficient enough to be able to pay the school, to be able to pay the fees of the child. So can the delay be as a result of payment of school fees? Salam alaikum.
In choosing next of kin, if the deceased and the next of kin are in a vehicle and it happens that both of them die, what will happen in choosing another next of kin?
Please, I appreciate the angle that the speaker has taken the topic from. As you notice, it's like hearing it again and again. But I want to call our attention to something. You know, when we are talking about inheritance, more so with the influence of the Western culture, we have this issue of property ownership between husband and wife. And immediately the husband dies, the wife wants to assume that we own this thing. Then apart from joint ownership, there is also another issue now, that a wife will own something and deliberately put the husband's name. You know, it happens, and I would love us to also clarify that. Then another issue is this. With the idea of assisted pregnancy, we have seen cases where the husband dies without the wife. She was yet to be pregnant, but they were in the process. Then after the demise, the pregnancy was instituted. Such a child, can we still call such a child an heir to the deceased? The assisted pregnancy issue is a real life issue.
Assalamu alaikum warahmatullahi wabarakatuh. I want to see from the Ustaz, how do we marry this together? The English law and Sharia law as to regard the residency. Now, you give an example the other time when you want to start your lecture, that the deceased, or let me say, the property owners, when he's still alive, can share 1/3. Can give out 1/3 to the person he wished, and at the same time, he has like a footnote, maybe to the person he wanted to trust that into. That okay, and I want my properties to be shared according to the dictate of Almighty Allah. Then somebody else, maybe among the children or whoever, well, is not pleased with it. Can we just ignore him or stay as allow him to go along with it? And maybe because of his own grievances, okay, we said okay, all what the man did, he has nullified what the owner has already written down. I don't know whether you get it right. 1/3 has been given out, and at the end of the day, I still have the belief. Maybe I want everything to be safeguarded by my own knowledge anyway. That okay, I want my property to be shared according to the dictate of Allah. Now somebody else, maybe among the beneficiary of the inheritance, now disagree with it. Can the 16 maybe allow him to say okay, that okay, am I share more with that Sharia stuff again? After he has made commitment.
Assalamu alaikum warahmatullahi wabarakatuh. First, I would like to make a suggestion concerning some sensitive and important topics like the one we received today and the one we received last month. Maybe probably, maybe the organizing committee can give maybe 2 Usrah or 3 Usrah for the completion of the topics so that it can be details to those that receive the lecture. That's my suggestion. Then my question is, what are the debts that children can pay on behalf of their parents after they have died. The debt, example of the debt that children can pay on behalf of their children after they have passed away. The examples.
Assalamu alaikum warahmatullahi wabarakatuh. I'm Mr. Bukari Messi, a poet. So my question goes like this. In what ways shall people recognize the authentic will of a deceased so as to avoid controversy? Is it through the recording of the first of the deceased or through the lawyer's signature? Thank you.
Before now, I heard a position that a child born out of wedlock will not inherit. But having listened to your lecture, sir, you said there are conditions that apply. Could you state these conditions, sir?
Assalamu alaikum warahmatullahi wabarakatuh. My name is Farouk Abbas. Mine is more or less a comment. I have just two comments. It's not like they're questions. And the first comment has to do with the lecturer's statement where he said we shouldn't delay in dissipating the assets of the deceased. And I want to back that up by saying that in most cases where people delay in dissipating or sharing the assets, we discover that some extended relatives go behind the back of the main family to go and apply for letter of administration. And whenever the nuclear family is now ready to proceed, they get to court and they discover that somebody has almost completed the processes. I'm involved in two cases where they've commenced, the other one was during publication that the wife discovered that some other relatives have gone to apply for letter of administration. And it's very important when somebody dies, even though we are mourning, let's kickstart the process of applying for letter of administration immediately. Because if you don't do that, the person who died, you might have a brother in the village or an uncle who is just waiting for him to die, and they will apply. And once they apply, it will stall the process of applying legitimately for the nuclear family. And you might be in court for the next 17 years, and whoever assumes control, because they have their own game plan, they will have assumed control of the major assets, and you will be in court and you will be deprived, and the family will suffer for that.
So I'm Karim. My question is Solara Karim. I go to the question straight. My question is about the one thought that a deceased might have written ab initio before to be given to somebody. Now, I want to ask if a virtue of the one thought, what that one person that will have the one thought will ultimately have will be far more than what each of the beneficiaries of the inheritance will earn. What do we do to ensure that we do not deliberately be unfair? So that's the question.
Assalamu alaikum wa rahmatullahi wa barakatuh. My own question is in the distribution of the property of the deceased. Suppose like husband and wife, the wife died and the husband bought the stove, the wife bought the gas, the husband bought the cooker, the wife bought the fridge. How can they share that one? Is the household property also be shared?
Sallu ala Nabi Karim. My question has to do with the one thought that is allowed to be given to people who are not ordinarily entitled to inheritance. And I'm looking at a situation whereby one of the children of the deceased is a non-Muslim, has left Islam, is not a Christian or whatever. And in sharing the property of the deceased, the provision that is allowed for charity, the one thought, will now take part of it and give to this person. Will it be in order?
Yes, from the questions that have been asked so far, we discover that there is still something which is still very common, is that it shows the level at which we have been so much engrossed under the English law and under the Yoruba custom. The question we are also asking also shows that we are still leaving Sharia behind. We are not considering Sharia at all. Because even from the presentation, from what we have read about inheritance, we have no say in inheritance except on the one third. What we can only do as Muslims is that, one, we need to intensify our efforts in ensuring that we give constant and regular enlightenment program on this aspect. And that's why I'm also happy that this thing is going to be featured on television, and I also want to crave our indulgence that we should also bring about the translation, either a translation in Yoruba language or in other languages. There is a depth of knowledge on the issue of inheritance. And for instance, if anybody dies today, the first thing that comes to mind is, does the person have a will? If the person doesn't have a will, what you discover, people will start processing the letters of administration. So we don't even bring in the issue of Sharia in at all. So with this aspect, we need to work on it. And then again, when you're talking about the division of property, distribution of property under the English law, under the Yoruba custom, you talk about Idigi, you talk about Jori. But as we have also analyzed, it's because we are very selfish in our approach. We want to be Islamic in one way, but when it comes to the issue of inheritance, we look the other way. And this thing is not helpful to our deen. Somebody asked me to ask a question on his behalf. I'm sorry, well, people have been asking, even though they said, where somebody owns a land and the person is deceased and the person was buried on that land, can the children inherit the land even though they also don't have a father? Assalamu alaikum warahmatullah.
I beg Allah the Almighty, as I answer these questions, may we be submissive in our hearts sufficiently to know that when Allah and His Messenger decide a matter, it doesn't behove a sincere believer to have any other thoughts. Even if we do not find it readily, but if it's not palatable to us, let us know that it is the one to whom we shall ultimately return that is dictating his own positions. On the first question regarding the couple who got married through the registry before they became this conscious of Islam, what should they do? It's very simple. Allah will not hold us to account to those things we did out of ignorance. So all they should do is they should avoid making themselves submissive to the dictates of the implication of registry marriage. If, for example, marrying through the registry implies that a man does not want to marry any other woman, and eventually the man decides he wants to take a second wife, which his religion permits, let them both know that if registry marriage denies a man that right, the Sharia allows him that right. So they should just treat the registry marriage as if it never existed. The same way when it comes to inheritance. Whatever is supposed to be the portion of a woman married through registry, let the sister involved in the situation know that that should not be a right for her to claim if it does not agree with what the Sharia provides for her, which is, in the case of a woman, if she's under a man and has no children for him, she's entitled to 1/4 of his property. If there are children, it is reduced to 1/8. You understand? So if registry marriage grants her a higher percentage, she should submit to what the Sharia prescribes for her. That is the way she can show sincerity and beg Allah to forgive what they did in the days of ignorance. I hope that is clear. Question number 2. Can we delay? Well, I want to correct this question. My sister said I mentioned that property sharing may be delayed for debt payment. Okay, not exactly so. I didn't say we should delay it for debt payment. Rather, I said we should deduct debts, those of financial obligations, before we share the property. So it's quite different from how she understood it. But nevertheless, what should be our attitude towards a parent who dies, leaving little children of school age, should we encourage that the inheritance be delayed until those kids have finished schooling? When we say debt, what is meant by debt is an obligation that is due on the deceased at the point when he died, not a future obligation that was not binding on him as at the time he died. Because if you want to say that, then several other obligations will follow. It won't be only school fees. As a matter of fact, the scholars say when a man dies, even the upkeep of his wife, who is in her iddah, hear that very well. When a man dies, the upkeep of his wife, who is in her iddah, is no longer binding on him. So it is the family, the relations, who should support her. Talk less of the school fees of children that is not yet due, but which want to plan against the future. If inheritance is given to those who are entitled to it, it is those relatives who should now see to it that those children don't suffer. But we cannot delay the distribution of inheritance in order to meet those future obligations. So we say debt, and we mean by that obligations due on the deceased as at the time he died. I hope that is clear too. Number 3, if the one chosen as the next of kin dies alongside the deceased, well, it is not as if, please hear this very well, it is not as if the Sharia prescribes that you choose a next of kin. Get that clearly. I only mentioned it because the environment in which we live requires us to appoint people as our next of kin for official documentation. This is why I touched on that, because we can't divorce ourselves from the environment. It is not the Sharia that requires that one must appoint a next of kin. But if we must appoint one, what are the qualities? The quality should be that the person is trustworthy, God-fearing, to oversee the distribution of the property. So should the next of kin die together with the deceased, it stops nothing. Will only require that whoever is chosen next in the family as the one trusted or elderly enough to be considered the one worthy of overseeing the property should fear Allah by making the property available when it is due for distribution to all those who are entitled to it. No more than that. Question number 4. Joint ownership between husbands and wife. Much as we appreciate that joint ownership is some expression of mutual love and trust, Islam does not encourage joint ownership to the point where there's no boundary between what belongs to the wife and what belongs to the husband. So if you're owning anything jointly, nothing makes it wrong that documents be prepared to spell out the share of the husband and the wife and any other person in that jointly owned property. But if there is no document, please hear very well, if there is no document regarding it, the Sharia says, Al-Bayyinatu ala-al-Mudda'i. The one who makes a claim has the responsibility of proving that claim. So if you own anything together with your husband and you don't have any document to show for it at death, you will need to prove beyond all doubt that you have a share in that property. So let no one think it is unbecoming, that is inappropriate for a wife to ask her husband to put into writing documents that will safeguard, that will protect her interest should this happen. It is quite proper. All right? Now, some items that are usually considered household items, like refrigerators, fans, stove, what have you. The Sharia says when a man marries, it is his responsibility to provide a good home for his wife, providing all that she needs in the home, like chairs, the fridge, and what have you, including cooking utensils. We are supposed to provide it for them. But if they assist us by bringing those things along with them, it is their property. All right? But because the asl, the origin is that it is a duty on men to provide it for their wives. Such items in the household, if there is no indication that they actually belong to the wife, at death, it can be assumed that everything in the house belongs to the man except the one that the woman can prove to be hers. Those things normally provided as household items, such as the seats, the bed, the chairs, men are supposed to provide it for their wives. So, if a woman knows that some of them belong to her, and she can convince members of the family, that's all right. And I think most family members would not make trouble over that. But should there be dispute over it, whether it actually belongs to the man or the woman, we go back to the basis. The basis that is that men are supposed to provide it for them. So the woman who claims that she is the owner will be the one to prove the ownership. Now what this means is, if we are providing things for our wives, and we remember that if our property is to be shared according to the Sharia after us, some things may not be clearly spelled out as belonging to them. We can assist by making sure those things we are providing for them, we write their names in the receipts. That's very important. All right? So that's all on question number 5. Number 6, examples of debts to pay. Yes, what kinds of debt can one pay on behalf of one's parents? Any financial obligation you can think of. If the father, for example, bought a house and paid only part of the price, and we are aware that that's what happened, we should pay the rest of it. If he borrowed money from someone and hasn't completed its repayment, we should complete it. If he went to school on loan and hasn't repaid the school for the tuition, we should pay it. All such things. All right? All these are examples of loans we can pay back for them. Number 7, how to recognize the authentic will. In the Sharia, it is required that the will written by a man be witnessed by 2 trustworthy persons. In the non-Muslim dispensation, whatever it takes will be better explained to us by legal practitioners here. But if it's in the Sharia court, we want people who would be standing as witnesses to the will written by the deceased to prove that truly he wrote that will in respect of that property. Now, where there is not such, and it is only by word of mouth that he made a wasiyah, to what extent it's tenable in a Sharia court of law, I may need to investigate. I can't answer that convincingly, for Allah's sake. Yes. Question number 8. Regarding the question of a child born out of wedlock, is the brother still around? He seems to have left. What I said was that as one of the relationships that people must enjoy with the deceased to be entitled to inheritance, there has to be either blood relationship, legitimate marriage, or master-slave relationship. I then said, with regard to legitimate marriage, there are questions regarding the products of zina, that should they inherit or not. That the majority of the scholars are of the opinion that a bastard has no share in the inheritance. But that some scholars, and amongst them Sheikh Islam Ibn Taymiyyah, hold that no, وَلَا تَزِرُ وَازِرَةٌ وِزْرَ أُخْرَى. It is a sin of the parents, not that of the child. It is a rare position, but I mentioned it that some scholars, amongst them Ibn Taymiyyah, while the majority of them say no, any child born out of wedlock, and especially if the parents don't go on to establish a normal Sharia compliant nikah subsequently, is disinherited, is not entitled to inheritance. So that position of mine stated can be verified from Majmu' al-Fatawa of Sheikh al-Islam Ibn Taymiyyah. He holds that position. It is strange, yes, but still I mentioned it as one position that some of the scholars have said. Number 9. Number 9 was more of advice for us that we should hasten to get letter of administration if we lose anyone in the family before others do it before us. Number 10, can we give out of the inheritance to those members of the family who have left Islam and who are not entitled to inherit? No, we cannot. And hear this. The Sharia prescription for apostasy is death. I hope you heard that very well. The Sharia prescription for is death. And this is why even what is supposed to be the share of that person that has left Islam, we are told the Muslim treasury would get it and not him. So he gets nothing from what the father or the mother left behind, and we should not give him anything out of concern for him. No. However, we are in a land where apostasy is not visited with the recommended punishment. We are in a land where many people were not properly taught about Islam, and that caused them to leave Islam. The scholars advise that if we're in a situation where the Sharia regarding apostasy is not meted out, we should make effort to enlighten those people who have left Islam. Perhaps they will come back to Islam, since that punishment cannot be carried out on them in our land. But in a proper Sharia environment, the person will not be there to even be given any portion of the inheritance. Number 11. Well, it has been answered that when we have household items, some of them bought by the wife, some bought by the husband, at death, who claims them? If the wife has means of proving that they belong to her, of course they are her things. If she has no means of proving them, those things that are required by the Sharia to be provided by the man, the family are justified if they assume that those things belong to their son. It is the woman who will now have to prove that they actually belong to her. Number 14. If children inherit a land where their father was buried, I think that's the question. That children belonging to the same father realize that their father was buried in that same land. So, can they inherit it? If I got the question right, there is nothing wrong with it. The only thing that may be wrong is, what do they do around their father's grave afterwards? I witnessed a situation where, when I came to live in a street, there was a portion of land with a grave, and I knew a Muslim man lived in the compound. When I talked to him about the need to be coming for regular salat in the masjid of the street, he told me that unfortunately he would be leaving that area in just a week's time. That the land actually belonged to his elder brother. His elder brother had died, and the children who inherited that land had sold the land out to a Christian denomination. And that in a week's time, they want to start construction on that site. By Allah, that land today houses a very mighty church in Laga Street. If you know Laga Street, there is a church in Laga Street. That church in Laga Street, that land was owned by a Muslim father of ours. His children sold it together with his grave to that church. So this is why we say we should all contribute to making sure we have proper graveyards for Muslims. So what they do subsequently is what matters. Inheriting the land is no problem. Yes. Number 14. Yes. Okay.
Before the last question, sorry, I have to cut the lecturer short because traditionally, once he's answered the last